I'm a little bit different than a fair number of people in that I see bad things happening, obviously, but I still believe strongly there's a lot of good and a lot of hope left. And I believe very strongly, Heather Top Benson wrote a book called This Nation Shall Endure. So that's just a little bit on me. I have 8 children now. I think last time I had 7.
Wow.
I had a baby last month.
Oh, wow.
Congratulations.
And so that's fun. We're starting to catch up on the boys. We're at 3 boys now and 5 girls. And so I was significantly outnumbered for quite some time. But I live in Salt Lake County, Murray, Midville area. This last legislative session in Utah, we're going to talk a little bit about it. If you're online, not from Utah, I'm hoping that the bills we chose will still be very relevant to kind of talk about a bigger picture. Some of the things that are taking place to understand, again, starting to see how pieces are coming together, how some of it ties into scripture a little bit from my perspective. And we'll talk about what it really means to be free and some of the things that we need to do to preserve our freedoms. And then we'll actually have some discussions about private member associations and what those look like, why they're important, some of the options they give us as we work towards these things. So if you ever have questions, anything you want to discuss, anything that comes to mind, I'm super happy to take questions, super happy to have a discussion. So just raise your hand, yell out, whatever you want to do. But yes.
Not a problem.
The latter is usually our style.
We don't demand that. Our children aren't here, so we don't have to raise our hands necessarily.
Just speak up.
First, I wanted to start with a bill that I actually liked at the legislative session. One reason I like this bill is because I did help with it. But to me, it's good to start with noting good things that are taking place. And so during COVID, one of the things that happened that we quickly saw is that doctors were nervous about going against what the CDC recommended or others recommended, even if they believed there was better ways to help people. And there were actually news stories about frontline doctors worried about lawsuits if they did something that wasn't fully approved. And it made it difficult. There's people we know that were close to us who passed away while in medical care because doctors wouldn't try certain things that their families were requesting that looked like they would help others. And so as part of that, as I look at that, I've always been of the opinion that the law should be a foundation for liberty, but if the law is getting in the way of innovation and progress and things, we need to potentially look at pulling that back a little bit. So this bill says that a healthcare practitioner can't lose their license and can't be sued for going outside the norm if they give the patient a written document that says, just so you know, this isn't standard, you can choose, it's an informed consent type thing, and here's why I think we should leave the norm. Here's, whether bad things have happened to someone or good things have happened, kind of disclose those things. And my personal belief is that when we have truly informed consent in healthcare, you talk about the risks, you talk about the options, let the person choose. They can follow their internal feelings, and I believe strongly that individual is the expert when it comes to health, for their own health. And they should be able to do what they feel is appropriate. And so this bill goes through and it actually spells out kind of that safe harbor approach, that document the doctor can give you, other practitioners can give you, health practitioners. And they won't lose their license with Doppel if they do that, even if they depart and deviate. And they can't be sued for the deviation alone. Now, let's say that they deviated and did something that was, like they were giving you an IV and they still did that wrong. That could still be an issue. They still need to do their treatments right.
Malpractices.
But the deviation alone isn't the basis for a lawsuit.
So did this pass?
This passed, and this was signed.
It did.
Oh, good.
Oh.
Yeah, so this got through. There was one major source of opposition. Well, there were two. One of them, after speaking to, they didn't oppose it as much. But the main source of opposition was the Utah Medical Association.
Of course.
Who represents doctors. They were not a fan of us making a safe harbor for doctors to do alternative
Isn't that crazy?
treatments. And they were very opposed to the bill.
But they didn't win.
They didn't win in the end.
That says a lot for a legislature and our population supporting you.
But one of the reasons they didn't win, it actually was interesting because the Utah trial attorneys who like to sue doctors, they were opposed to it at the start until we had a discussion with them about the intent and what we're trying to do. And then they actually came in line with it and supported it. And once they supported it, it was very difficult for UMA to continue their opposition when even the attorneys that usually sue the doctors were in support. So
That's awesome.
So it was neat to see this bill, and the hope is, and another thing it does is it also lets doctors talk about what they do, or practitioners, because one of the issues is practitioners get concerned. Do I dare say anything? Do I dare say that I depart from norms? And then it makes it hard for people to get information if the doctors have figured out something that's helpful and good. And so it also lets them talk about it on their website and other places.
What was the bill number? I can't read it.
The bill number is SB 171.
And it's, I mean, everything's signed, sealed, delivered, done.
Correct, until the next legislative session.
Yeah, until next year.
Who knows what happens then? But as it stands, this is a great thing, in my opinion, because we're starting to allow doctors and patients, health practitioners, to work together to say, this isn't working for me, I don't want this. And let's try something else, and the doctors have a safe way to do that without threat of losing their license.
That's
or
amazing.
Yeah, and my
It's a
doctor,
huge breakthrough.
he's
Those
from
people are
Germany, and
surprised.
he's like one of the most liberal. If you think that works for you, that's great. Love it. And I asked him, I said, would you prescribe ivermectin? Oh no.
Really?
Oh yeah. Yeah. So
And it is scary for the doctors because
Yeah.
there's such a strong push from the establishment.
so
against
now
it.
they can prescribe ivermectin and hydroxychloroquine, and
Yeah, as long as they have that informed consent with you.
that's great.
And
Can I request that they do that and say with the informed consent?
you can, and one of the things, I haven't done it yet because I'm still recovering from the session, but we're going to draft a form that the doctors can follow.
I know, the session was just...
And
Legal cannabis? Have you got your cannabis card?
so I don't. But one of the things it does not allow is if there is an express ban on something, the doctors still can't do it. So it doesn't let them violate
Yeah.
an existing law.
So what's the status of hydroxychloroquine and ivermectin? Does it have an express ban against it?
Not to my knowledge.
Okay, well, my doctor prescribed both of them for me.
Yeah, and some doctors will.
Yeah.
And there are some doctors who have been comfortable venturing out and doing some things, but many don't. And even the ones that do generally try and restrict it to certain people they trust more or have more working knowledge with.
Exactly.
Because if you're a new person going in, are you a mole? Who are you? They don't know. They may not do that for you.
Yeah.
And so again, and we're not talking about just ivermectin. There were some great doctors that testified in support of this, that explained things they were doing, why it was necessary, worked with the committees on it. And it was one where, again, I was very appreciative of the legislature taking this step. And it's something that, while kind of small, saying you won't lose your license, you won't be sued for the deviation alone, I think it can have a big impact.
Very big impact.
And that's something that, congrats to Utah, kudos kind of thing.
Yeah.
So we'll
So is
start on
that
a
just
positive note.
medicine, or is that treatment, or all encompassing?
All encompassing for a healthcare practitioner.
Great.
If they're departing from the norm
That's awesome.
that's established. And so yes, so you could go to your doctor and say, hey, did you know about this? Let me get you that that form you can use, fill out, and then you can do this. So, but again, I need to make the form still, but that is on my to-do list.
Great.
And we'll put that up for practitioners. So,
You'll need to send that to me so I can get it out to the sisters.
yeah, that'd be good, right? Make sure everyone can start letting their doctors know.
Yeah.
Yes, do.
But now we're going to kind of go into a bigger picture discussion with some of the issues. And then I guess the other thing is if you're outside Utah, that last bill, it can serve as a great blueprint for other states
That's what
as
I
well.
Mm-hmm.
And so if you want to look that up, try and take that to other states.
Well, before we jump on that one, Would midwives be covered with that? I just know that, like, I had group strep B and my midwife forced me to do the antibiotic, even though I had a paper prepared by a lawyer that said, if my baby dies, I take responsibility. She still forced me. And, you know, so in the state of Utah, how would that work with midwives?
So there's two pieces to understand about it. It should, so that, again, that applies to anyone licensed with healthcare or doing healthcare types of things. It was
Anyone
expensive.
licensed, okay.
But just because the law allows them to deviate doesn't mean that you can require them to deviate.
Oh.
Okay, that makes sense.
So they can still put their foot down and
So
say,
Yeah.
I still don't have freedom.
Well, it's a request on your part.
Well, you just have to find a
Well,
doctor
it's,
that
remember,
will
we
allow.
we have to balance both freedoms in the sense
Oh.
that a doctor can't be forced to do something they're uncomfortable.
Oh,
Yeah.
I'm actually
okay.
highly
And that's
opposed to
really
that
right.
Yeah.
personally.
I agree.
Okay.
But it's to say that assuming the doctor's comfortable with the situation or with you or
Oh,
whatever,
okay. So then
they now have a basis
They would
to
have to
deviate.
find a
You need a
midwife.
different midwife.
Yeah.
Probably
Yeah.
Well, I did. I
State
never
right.
used that one again.
Yeah.
She was out.
Yeah.
But in the meantime, it was a really horrific thing.
But yeah, so yes, so
Ruined
this
it on
is
my
this
kid.
is again trying to balance those both freedoms on both sides, where the practitioner needs to be able to have the freedom to say, I'm not comfortable with pastel, sorry, or the ones that are comfortable, to give them the ability to do that without the fear that's associated with it.
Thank you.
Yeah. So then there's an interesting kind of silent battle playing out right now that is very interesting to be aware of, and it involves the legal profession and law and access to law. So Utah Supreme Court, and this one is a highly, among those that know about it in the attorney world, there's a lot of attorneys that still don't know it's happening, but among those that do, there's a pretty deep divide about whether it's a good thing or a bad thing. And so I'll just share openly, my opinion is some of what's happening is good, but it could potentially be twisted to be bad as well. So it'll be one we kind of have to watch carefully. But the Utah Supreme Court, a couple of years ago, had a justice who's very forward-thinking, very liberal in a lot of his thoughts. But he's been very concerned about the fact that access to legal services is so incredibly expensive.
Yeah, it is.
Which I have a high concern for that. The rules, the malpractice, all these different things make it so that if you need to access legal services, it's very prohibitive for most people. If you get sued, very few Americans can actually afford to defend a lawsuit. It's just the reality of where it's at. And in Utah, they have so many requests for pro bono services that even if every single attorney donated time, it still wouldn't cover all the requests for the help. And the courts are just inundated with people that are just there by themselves because they don't have any other options. And so it's a huge drain on the courts, it's a huge drain on the judges. He's going, this isn't right. And so he's kind of looking at it, I think, from the court perspective and also the justice type perspective. My personal feeling is that we lose freedom if we don't have access to the law and to courts. If it's so cost prohibitive that we can't even file a constitutional challenge, we're losing our freedoms. Mm-hmm. That's the way I see it. And so he pioneered this, what they call a sandbox, a regulatory sandbox, where they started permitting attorneys to break some of the traditional rules that have governed law firms and things for quite some time. And the goal was to try and make it so that there'd be outside investors who are not attorneys who would put money into law firms, software systems, other things like that, so that we could automate some of the law, make it so there's software that can make it more accessible, reduce costs, and try and experiment with a number of things to see if it increased access to law and legal services. So in principle, I'm highly supportive of the concept. The concern is that some people have is that it opens up to big money, and then you have people like Google that start to control the law. Mm-hmm. And so again, I say, yeah, this is something we're going to have to kind of watch and see, if it can play out, if it can't. But this regulatory sandbox, a law firm can apply, they can become part of it, and then they file reports with the Supreme Court monthly or quarterly, depending on how high of a risk category they're in. And they get to then have permission essentially to do things differently. And so the program's been going for, I don't know, 2, 3, 4-ish years, somewhere in there. I forget exactly, time passes so fast, but the Utah Legislature has increasingly become hostile towards it. They don't love the program, and they want to return it to this good old-fashioned legal model that we've had for 100 years that, allows just, for example, one of the rules in law is that only attorneys can own a law firm, and that's that only attorneys can own a law firm. So shareholders in a law firm can only be attorneys. You can't have outside non-attorneys have ownership in a law firm. But the rules under the Supreme Court allow non-attorneys to own law firms so that they can have a share in that investment if they're going to put money into software or whatever else. From my perspective, there's no really good reason to limit law firm ownership to just attorneys, because they like to say, oh, we don't want big companies coming in because that creates this perverse incentive for people to make money instead of provide legal services. And I say, you don't believe that attorneys have that perverse incentive themselves. There's nothing magic about us. It's like, oh, we're just these saints that don't want to make money. No, like, the same capitalist principles apply whether you're licensed as an attorney or not. But what it does is it certainly hurts the consumer. And there are, I think, checks and balances that can be put in place to help balance out the demand for that. But one of the best checks and balances on someone trying to make too much money is competition.
Yeah.
And if we can facilitate that competition rather than lock it up in a tight firm where there's not enough, access to services, that's a good thing. And that's going to check and balance that issue. And again, the Supreme Court justice agreed with that. There was a lot of heat back on him for it, a lot of pressure from the legal community. The Utah Bar doesn't necessarily love it, from what I can tell. And so the sandbox that's testing out these concepts, gathering data and stuff so they can report on it, has been adopted in a few other states as well.
So it is here?
It is here.
Okay.
It is here.
Do you know what other states they're in?
I believe that Arizona has it. I think there's 2 or 3 more.
Does Idaho have it?
I haven't heard about Idaho having it yet. Because again, it's a very contentious issue. It generally takes, if you're a super conservative, on the super conservative side, a lot of them don't like this. They don't like changing the practice of law. There's something about the law that says, oh, don't touch us, don't change anything. And we're stuck in the same model we've been in for a good 100
So
years.
I'm confused. The sandbox gives legal services to people who can't afford it? Is it?
Not necessarily. The sandbox permits attorneys to have different law firm ownership structures, to be able to share fees with non-attorneys. Because one of the other prohibitions that stops advancement is that you can't get a % of attorney's fees if you're not an attorney. So you can't have a deal that says, hey, if I bring in 20 clients for you, I get 10% of the fee. That type of work. You're not supposed to share your fees with non-attorneys. Again, you can share them with attorneys. So if an attorney's in your firm...
Well, the same thing in real estate.
Yeah.
I can't share a commission.
So like
So,
the
with a
Brunson brothers that are
non-agent.
taking on their own, law firm, they can do that legally because of this.
If they apply and get approval with the Supreme Court.
Okay.
And the Supreme Court has been doing things where they've opened up more practice of law to paralegals. So they've actually removed some of the things that attorneys used to be able to only do, and now they're letting paralegals do it. Some of the tasks that really don't require a ton of attorney involvement. And so they are trying to make things cheaper, some of the more needed services. But the point to understand is that there are forces in society that are trying to innovate with the law. And again, I highly support that. I understand that there could be risks that come from it, but I believe strongly we need to start innovating, break out of our 100-year-old model, and increase the access to legal services.
Are the paralegals bound by the same laws as the lawyers?
Yeah. Yep, so paralegals they have to follow the same ethics and all that kind of stuff as well. But under their license, they can specifically do certain tasks. A lot of them relating to divorce and divorce filings to help people with those. So it makes it much cheaper. to be able to have some representation and help.
Does a paralegal can they have their own company then, or do they have?
Paralegal can have their own company.
They can.
Yeah. And again, they have rules about what they have to disclose to you and say and things like that. And it's pretty clear that you hired a paralegal, not an attorney type thing when you work with them. But it's better than usually trying to do it on your own. And
A lot of times the
honestly,
paralegals do all the work.
correct. The paralegals in a divorce scenario are doing almost all the work anyways.
Yeah,
Attorneys do very little of
especially
it.
if both parties agree. You know,
Especially if
they've
you
already come
agree.
to an agreement
Yep.
themselves.
Yeah. Attorneys are generally, in a divorce scenario, they do a lot of the arguing back and forth and the in-court stuff. But a lot of them don't draft the documents. And there are a number of situations where that's the case. And so the law is trying to say, paralegals are doing it all anyways, let's just let them do it directly for people. And move into that realm. But again, there are forces that are opposed to it. They don't like the threat to the, whether it's their invested funds in the big firm model, or whether it's the fact that more people have access to justice and the law, I don't know entirely. But we see some of these things playing out. This bill wasn't a direct attack on the regulatory sandbox the Supreme Court set up. And we'll look at one in a minute that is more a direct attack on it. But this is a very interesting one that, again, in the larger context of law and how we're starting to change some of the things. Delaware set up a court quite a few years ago where they said, hey, if you are a business and you file here, we have a court specifically for businesses. And our judges are so trained in business things, they're business experts. They'll get your stuff, you don't have to take it in front of a jury anymore. And a lot of businesses have opted to go to Delaware because their judges have the best decisions or whatever, and the most wise choices or whatnot in it. And so Delaware now has millions and millions of businesses that incorporate there. They charge
Same with Wyoming, right?
$400. Wyoming's a slightly different route they took. Wyoming's trying to make it so it's just the wild, wild west. It's like, oh, you can form a business here, we won't ask any questions.
Can be good.
And so it can be good, but it also can really facilitate a lot of
Criminal.
Yeah.
all kinds of different things through there. And so again, that's I don't know entirely. That would be interesting to see how that one plays out for Wyoming.
Is this legal sandbox, is there a limitation on how long? You say that they're gathering information and stuff. Is there a set date or something when they have to produce the information to the legislature or anything about it?
Yeah, so the Supreme Court is pretty open about things. They're putting out information as they go along, reporting on things. So under the Utah Constitution, the Supreme Court's tasked with regulating the practice of law, generally. So that's kind of their jurisdiction. And so the Utah legislature can't expressly ban this because they don't have the constitutional authority to, so they have to kind of approach it through different means. But yes, they are, there is, the Supreme Court's trying to be quite open about the situation and about the findings and whatnot. And so far, surprise, surprise, there haven't been really any harm to consumers that they can detect in these changes. And that could be slightly biased in that you're reporting to the Supreme Court every month, so you're going to be a little bit more on top of your game probably than you would be otherwise. But in what they can tell, every firm that's in it, they have to have this big thing on their website that says, hey, we're regulated by the Supreme Court, you can file a complaint directly against us, type of thing. But if we go back to, so outside of the sandbox for a minute, Delaware set up this court, and it's generated Delaware an incredible amount of money because all these businesses file there, pay the filing fees, pay the renewal fees. And little Delaware has a strong profit center in that its courts are reputable, businesses like being there because it's more predictable on how it comes out, and so they make money. And so Utah said, why don't we do a business in chancery court? We can become like Delaware. And so this actually sets up a whole new court in Utah that's never existed before for business disputes above $300,000. And it says we're going to have 2 judges that are highly conversant in business, understand it all, and we are going to put them here in the state and give Utah credibility with its court systems and businesses to make it a place people want to be business-wise.
So that's in place, and is it going to be set up immediately, or is there a time that they're
I think
getting it together?
that they're looking by next year for it to start. So this one did
Beginning
pass.
of
This one was signed.
2024?
That one
Yeah.
did not pass though.
It did.
Oh, it did.
Yeah.
So
any
it's gonna
bill that
be
I show
in-
you here passed.
Okay.
Anything
Oh.
we talk about passed.
Okay, so it's gonna be an LLC. People can do that now here.
So
You
people
still
can do
already
LLCs
do
here.
it.
We've always been able to do
Yeah.
that.
Well, I have
But
one.
assuming that you have a lawsuit over, if you have a lawsuit that involves your business,
Mm-hmm.
you can put the lawsuit in this business court now as opposed to the general court.
That's a smart idea.
Okay.
It's just a no-brainer
Well, and so this is
for
where
judges.
I look at it and say there are some good things with it, but I have some concerns too from
Okay.
I do.
a freedom-based perspective. Because one of the pushes has been to say we need experts on every subject matter.
Yeah.
Hearing that dispute. And so think for a minute during COVID if an expert judge heard every health dispute as opposed to a generalist judge.
Yeah.
Would you feel more free or less free in that scenario?
Depends on the prejudices of the judge, but probably less free.
But again, assuming it's an
Less
expert on
free.
health,
Less free.
Yeah, but where does he getting his
Doctor,
expertise
lawyer.
from?
Yeah,
Yeah.
expert is
Right now,
Yeah, that's
absolutely.
very
highly
much-
subjective.
Yeah.
and so if you start thinking about it from the perspective of when someone becomes an expert on something, what starts to happen to them is that they start to kind of close their mind to all kinds of other
Yes.
things, right? Which again, in certain disputes can be appropriate and helpful. But there's big things where there's a lot of academic push to say, let's eliminate the jury. Because when Apple and Microsoft go to battle and they have a 3-month-long trial, no juror can remember all the information and they're just confused and they just make some random decision. There might be some truth to that. But we have this push to start to eliminate the jury. And one of the things the business court does not provide for is a jury. It's just the experts, the judges there.
That's how we lost prayer in school, an expert of a psychiatrist.
And so we
no more
have
experts.
this scenario where, again, in a complex business decision, you might not want to have a jury there. The other side might want it for tactical advantage reasons or whatnot. But when I look at the business disputes, so for example, if this is a case I'm in currently, one of the battles being played out in the nation right now is whether or not non-compete agreements are appropriate. And whether they should be enforced or not, whether they violate the competition that the law says is supposed to be there. Because anything that stops competition generally is supposed to be illegal unless it's allowed. Currently, the FTC has taken the position that non-competes stop competition and that they need to be banned. And so they actually have an open rule out proposed that they're looking at to ban them across the nation. But it's been interesting in this case because we go into court and talk to a generalist judge on this non-compete issues, and the situation specifically relates to licensed providers who assist children with autism. And they left one location and went to another. And they're accused of having violated a non-compete agreement. But if they're not allowed to work in Utah, it decreases access to everybody here in Utah who needs help with autism, the children, the families, the schools they operate in. And currently in Utah, there's a long wait list for these services. So if you have a child with autism and get the diagnosis, you're going to wait 1 year to 2 years to get services anyways. And under Utah law, a non-compete can only be effective for 1 year. So in going to talk to the judge, if we go put in information about the fact that families are going to be impacted, hey judge, if you enforce these non-competes, these families are going to lose services, these kids are going to be at an increased risk of suicide, all these different things. There's a bigger public policy consideration for the judge to weigh in whether they enforce these or not. But if you take that in front of an expert on business, I don't think the expert's going to care that much about those things. They're just going to say, it's a contract, we enforce contracts, whatever it says kind of thing. And again, I've seen in courts quite often where there are situations where it's just, it truly is a contract, it truly is just what people said. But there's times too when there's considerations to be taken into account.
So if you've got a situation like that, are you gonna be forced to go into business court, or can you choose?
So currently in Utah, you can get out of this by requesting a jury.
So you can request
Oh.
a jury trial.
And so the way to get out
That
of
was my
court,
next question.
if it's filed there, is if you request a jury trial, the law is going to kick you back out to a normal court. But again, to me, the concern at the moment is we're starting to set up this notion that experts here, business disputes, not juries. And to me, it's starting to further cement that in as we get more and more people into this. At some point, it's going to be just, oh, you're a business dispute now, we need the experts to hear it. Oh, you're a divorce dispute, we need the divorce expert to hear it. And again, Utah's kind of gone that way with divorces, where most divorces go in front of a magistrate who just hears divorce issues. And again, it's one where they hear so many of them now, they're such experts that there's almost no human connection or emotion left. Which can be good in some situations. You just need to help, move things along, but it can be bad too in other situations where there truly is a need to consider that. And so it is something currently where you're not stuck in it at the moment. It's an optional thing for people. But the creation of the court, the fact it can start to generate revenue, it starts to create a really interesting incentive too, where if we get the disputes in there and we have some good decisions that come down, we're going to be generating more revenue for the state.
So how's it working in Delaware? Are they locked into
The court, the business
the
disputes.
business dispute court?
To what I know, they are.
So
All the
it
business
gravitates
cases go
to
there.
that, yeah.
But again, one of the concerns I have is I look at it and say, on one hand, it's really smart of the government to say, let's have people voluntarily pay us money to form companies here. That's a great source of revenue, right? Less taxes. But on the flip side, I say, but should the government be in the business of making money?
No,
Is that a good thing?
it creates evil.
Should that drive our decisions, especially in our courts? If our court system is now something that can generate revenue, it starts to facilitate, if you can start to say there's a connection now to making money off of court disputes, I don't know, it creates a really interesting it creates an interesting incentive or a perverse incentive to, again, where I just get a concern saying, how does this play out from a liberty perspective?
So how would this affect like the health area that you're kind of talking about? Like if you had a child that you wanted to treat that had cancer a certain way and they said, no, you have to hospitalize and do chemo or else lose your child. I mean, is that kind of outside of this or would this be part of that?
That's a good
too?
question.
Yeah, so currently that one, as it relates to a child in a healthcare system, would not fall under this jurisdiction of this court. But if it were two healthcare providers against each other, it could be considered a business dispute, potentially. And again, you would have these experts now that make these decisions. And to me, again, the concern with someone becoming so experienced in something is, well, what happens when I raise a constitutional argument? What happens when I just appeal to just the general liberty basis or something to say, this is a little outside that? I think that the more expertise someone gets, the more disconnected they become from the other things that are happening. And I think we saw that during COVID, where the government's response is, oh, let's save everybody, so shut it all down. You go, well, that's a health expert perspective,
They
sure.
they didn't even believe it. I'm sorry, it was all political.
But I actually think there were health experts that believed that the way to stop COVID was to shut things down,
But
right?
big fact.
From a health perspective, it makes sense, logically.
Yeah.
But when you put suddenly everything else in perspective of all the damage, all the destruction, all the mental, social, whatever issues that follow,
Business.
you say, this is why we have politicians in the political process, right? Is we're supposed to have a scenario where the politician isn't an expert necessarily. The Constitution never said to only appoint experts. And I think it was because They wanted someone that didn't know everything and didn't feel they knew everything, so they'd listen to all the sides, right? So what happens here? So we consult the health experts. Okay, the health experts say to shut the world down. What do the economists say? What do the mental health experts say? What do these others say? And that political process should play out where someone then makes a decision to say, I've weighed all the experts' recommendations, and this is what we see as being the best path forward that balances all these. And I feel that judges generally try and do things like that, where they're open to these things. And so I've always been concerned about the push to make judges experts, because I think we start to shut off some of these connections. And that's always been a concern for me.
And with only 2 judges.
With 2 judges, for all the business disputes in Utah.
But it seems like there should be 3, because 2.
Well, so understand, only
they
one
don't
hears your
decide
case at a
once.
time.
Yes,
It's just there's 2 that sit there, so one's hearing cases, another's hearing cases.
And
It's
so
just to
for-
say that we're
They're
having
not
2 experts.
collaborating on the cases to come to an agreement. It's
No.
just, they have their caseload, they have
Yeah.
their caseload.
Yeah. So right now, if you go in court, you get 1 judge. You sit in front of 1 judge. It'll be the same in this court. It's just that there's 2 of them that you may appear in front of. But the other perverse incentive I think it has is currently in Utah, if you file a case in Salt Lake County, there's a lot of judges you can appear in front of. So if I'm an attorney and I'm really digging deep on constitutional issues or something and making the judge angry at me, I may never see that judge again. But if I'm a business attorney and I've got 1 of 2 judges I'm going to appear in front of for all my next clients, am I ever going to want to take that judge off?
Right.
No, oh, that's
Huge
a good
difference.
point.
No, there's no way I'm going to want to take that judge off because my whole career is tanked at that point as a business attorney. If I can't appear in front of that judge again and win because they don't like me.
Yeah, wow.
That's a
huge.
scary thought.
And so these are some of the concerns I have with something like this, where
Any checks and balances in this?
Yeah.
so they can go on appeal, kind of saying you can appeal your decision to the appellate courts.
And it won by how many votes? I mean,
I didn't look at the votes, but most of the things. So this is a sad reflection of things. KSL even called them out on this in the legislature. So the Utah legislature this year, you can read the KSL article on it. They passed a record number of bills, more than they've ever passed in history.
Mm-hmm.
They had a record number of unanimous or almost unanimous approvals for bills. The median time spent on a bill, considering it, was 10 minutes.
I don't even know what the bill is.
Yeah, that's no.
And KSL even called them out specifically, so I think I believe it was Senator Weiler, that he got up in the Senate and he said, hey, here's the bill I'm sponsoring, I'm asking you all to vote for it. He read the description of it, shared a little bit about it. Every senator voted for it, and then he sits down
Weiler?
and realized that he read a description for the wrong bill.
Oh.
And all that a senator had to do to realize that is they just had to look down at their screen and see that these highlighted provisions that he talks about there were off from what he was talking about. Not a single senator even noticed. Not a single senator checked
So
their
they're
screen.
looking at the dollar signs, not
Yeah,
what it's
and
gonna
their-
do to the
and their
people.
comfort zone.
And so this
They
was
don't
something that even KSL went,
That's a problem.
this is an issue. And Governor Cox had a meeting with them and he just said, hey guys, Utah's actually really concerned. He goes, you lost a lot of credibility with how many bills you rushed through this session. He goes, he says, I'm signing them this time, but I'm not gonna sign as many next time because we need to preserve. And so the people though do have a concern enough to, the governor's kind of saying, hey, what are you doing here guys? This was a lot of
My
bills
faith in Cox is 0.
to push through here. And again, that's just to say, if Cox is having to talk about it, it was an issue.
So what were they calling you out on then?
Sorry, what's that?
KSL, what did they call you out on?
Oh, KSL didn't call. I was saying that KSL called the reps out on this.
Oh,
That they were the ones that put that out to say median discussion time of 10 minutes per bill.
Well, in the meantime, on this one that was Weiler approached wrong, they didn't really look at it, did they?
So Weiler did get up. KSL did note that he got up and said, "Oh, sorry everyone, I'm gonna have to motion that we revote on that because I actually read the wrong one." And then they just
Well, good for
voted
them.
again quickly, and it was unanimous again. So it was corrected.
At least
But
it
to me,
becomes-
the bigger
So
concern
it becomes
is that
obvious that they're not paying attention.
they didn't even look at their
Yeah,
screen.
Good point.
they didn't even look at their screen to say, "Am I going to do a check myself? Am I going to read that they read every highlighted provision,
They're
but they
just a little
skip
too
one?"
comfortable, that's the problem.
Something. And so that was a concern there.
How many bills did they
How many bills? It was over 500, I believe.
Oh.
Every one of them costing you money.
Any bills that limit how many times that people can appeal? My grandma's will is 7 years in appealing. Like she
Yes.
died 7 years ago.
Good
And they keep appealing, both parties keep appealing. Like that to me is where there's an injustice in the system, where lawyers are getting paid, they're getting
They're chewing up all the
money from the
proceeds.
family
Yeah.
because the two family members can't make an agreement.
Yep.
But is there a law that says, hey, let's give it 5 years, and if you guys can't agree with this, it's like, here's, it's done.
There's currently not anything addressing the number of appeals because it's one where, from a due process perspective, it becomes very difficult to put limits on. The thing that the courts could do is start to maybe put a little more teeth in the frivolous appeal type scenario. But traditionally, courts are very reluctant to call an appeal or a case frivolous. It's very hard to get a judge to say it's frivolous because we have a constitutional right to petition for redress of grievances. And if they start to make this call about, oh, that's completely frivolous, then, well, if you want ivermectin is now considered frivolous in court because the health expert disagrees. And the courts have actually been very circumspect to say we're not going to go down there unless it's just so outrageous and kind of out the bounds. But it puts us in this tough spot of we're stuck. You can be stuck in a lawsuit. For example, the Exxon Valdez oil spill in Alaska that decimated all the fishermen, that ruined all these things, destroyed lives. It took over 20 years to get through all the appeals. It went up and down, up and down, up and down. Most of the people that were affected by that lost their whole livelihood, were dead before there was a payout. And absolutely it's not right. I'm not pretending it's right. I think there are some things we could do, such as actually mandate that things have to happen faster. You know, that once you appeal, they can't just sit on it for a year at the appellate court. It's kind of like, hey, let's move along. If we need to hire more people, let's hire some more people, but let's move this along. Because even if people appealed a lot at that point, but you could get through it in a month or something, it's a very different scenario than if you're waiting, oh, they appealed, so now we're stuck for another year waiting. And that's something I'm a big fan of, promoting faster court times.
Yeah.
And that was something even, I don't know if you followed Brady Brammer's House Joint Resolution. This was also another attack kind of on the legal field, where the courts right now in Utah said with the abortion ban, they said, we're going to put a stay on it, we're concerned about this while we evaluate the constitutional side. And then they're just kind of sitting there.
Yeah.
And so Brady says, I'm not a fan of letting a court issue a decision just to wait and see and kind of check it out. They need to tell us right up front if it's unconstitutional or not. And I had deep concerns with that because there are some times where a court needs time to let parties present evidence, gather evidence, do things.
That's true.
And they need to be able to put a stay on it. He just took that away completely, which again concerns me. My approach was to say, if a judge says we need to wait and see and let people gather evidence and arguments, my approach was to say, well, just put a time limit on it.
Yeah.
Just say it's no more than 6
Common
months
sense.
or
Yeah.
3 months, but don't take away the right for a court to say, whoa, there's some crazy stuff here, let's just put a break on it for a second. But that was one that they were pretty insistent on, and so they completely took that away, essentially, to say, on the constitutional stuff. And so again, kind of this power struggle between them right now with the practice of law. This had been one that had been in place for decades and decades and decades, helped in very particular situations, important ones, and it's gone now. So.
Back to checks and balances. In the Constitution, it's when judges go haywire, other judges can judge them, lower court or upper court. Anything like that in here?
So again, the same in that these judges, any of their decisions can be appealed, and they're still
Appeal is different than taking a judge out.
correct. And the only way to take a judge out is actually through impeachment, and that doesn't happen with other judges. That's actually the Senate and House that impeach. So there have been a few federal judges removed for impeachment. The House will impeach them, and then the Senate will convict. But the judges don't actually judge the judges in those proceedings. Right? That one's from the Book of Mormon, where the judges judge the judges. But here we have the Senate.
We should have it, dang it.
Well, again, it's it is interesting to say.
Depends on how corrupt or good they are too.
Yeah. Yeah.
Um,
No guarantee there.
So is this law unconstitutional because they make money for the state?
Well, it's not a direct making of money. The court itself isn't generating the money. It's that if the court can have reputable enough decisions, people will make the decision to then, form their business in Utah. They can charge licenses and taxes and things.
Saying the government would make money.
Well, so the government will through the licensing of the businesses. So Delaware makes millions and millions and millions through people that choose to license their business in Delaware. But there's not this direct correlation between, we issued 15 decisions today and now we have $1 million extra. It's just they're building credibility within the state, which then incentivizes businesses to come. And so that, it's not a direct enough link. And again, people would point to this and say, it's going to be years before this does anything money-wise. But certainly one of the considerations for it is we can bring business to the state. We love to bring business to Utah for some reason. Like, we're in a drought and we don't have enough water, but hey, let's bring more businesses. If we can put more data centers here that consume all our water, let's do it. And I don't fully understand why we have such a love of money, in the sense of, yes, we need some business, I get that, but why are we working so hard to shift all these things to say, let's bring the business? I don't know entirely.
Can I make a quick comment? I think even church members want to appear prosperous before the Lord prospers them, and they're racing like crazy to get there. That's just one observation on my part.
Potentially. We may have this thing where we judge ourselves, how righteous we are based on how much we make, I don't know.
Thank you, I rest my case.
The Lord's blessing me, so I'm really righteous.
Yes.
Yeah, I have money, so I must be righteous,
And
right?
you're poor, and so
my
you're really
gosh.
unrighteous.
I have another box question.
Okay.
So I've been hearing that our food, that we get 70% of our food out of the country. So it's just a question. So when I go shop and I'm buying organic, and let's say this company's in Sri Lanka, and they're selling me an organic product, but are they following our national organics rules, or do they just write organic and send it to us?
No, it's a good question. It's one where, do we have anyone there checking? They can say whatever they want, right? So one of the things that happens right now with chocolate, for example, is most chocolate is produced by child or slave labor in Africa.
Oh.
It's actually pretty egregious if you look at where chocolate comes from, for the most part. So there's a few places that say, we source all our chocolate from places that don't use child labor or slave labor. It's ethically sourced, whatever, but it's quite expensive. But the companies here say, no, we don't use child labor, because every contract we sign with someone out there says that they don't use child labor. And so when they contract with a supplier from Africa for chocolate, the contract says, I agree I won't use children, I agree I won't use slaves, yada yada yada. And everyone says that in the contract, and so the companies here say,
We're good.
all our people are good. They're not doing this.
But who's checking?
But they are. But who's checking what's going on? And so part of it is, most of what's happening is they're signing things in contracts saying what they did or didn't do. But if the company itself that's bringing the product over and things doesn't have the checks in place to say, is it really there? Is it just kind of, who knows what? We don't know. From a regular perspective, there's this incredibly strong incentive where people, if they want to do business with America, they're kind of put in a position where they're incentivized to lie.
They have to what?
They're incentivized to lie.
Oh.
And the businesses are incentivized to not check. Because if they check, they don't have any source of chocolate, for example. And that's just one of the things that happens. So, yes, understand where things come from. Understand kind of how the whole process works. We don't know. If grapes come in and they're sitting there and say, those look organic. That's basically the extent that they've done, and they just, someone has checked a box and signed something.
Yeah.
So.
And meanwhile, in India, they spray paint the green all over them. Make it look nice.
Yeah, so we'll go on. So this one was interesting. More judiciary amendments. They actually.
Senate Bill 129?
Yep. Senate Bill 129. Utah had a process for selecting judges that used to involve a certain number of people from the Republican Party, a certain number from the Democrat Party, certain number of independents, had to have a lawyer, had to have a non-attorney, you know, kind of this mix of people from the community. And this commission would evaluate judicial applications, and then they would recommend up 5 people to the governor, and the governor had to select from those 5. This changes that to say, we want the governor to choose who's on that commission.
No, that's the worst thing ever.
And
So
now
we just sold out.
so now the
Yeah, just sold
governor
out.
gets to choose who's on the commission.
Which commission is that?
This is the Judicial Appointing Commission.
That's what they did with the, the Utah State School Board when I first moved here. It was all chosen just by the governor, and then we had to fight to.
Get back, right? And so this is one where the Utah State Bar generally doesn't take legal positions, but this is one where they actually came out like, whoa, we're so concerned about this. This is a big deal. And so it is one that's, again, just to be aware of. The governor now appoints his own, will as of next year appoint his own commission for appointing judges.
How do we
And then this one does at least
How can we
include-
try to work on repealing that as
Well,
as people?
You have the Utah Bar in support. They're probably going to be trying to chip back at this. Again, it doesn't take effect until next July, I think.
Utah Bar is in favor of repealing this?
Mhm.
Okay.
They want to go back to the original thing. And so I would imagine there's probably going to be a bill again about this next year. This one got quite a bit of heat. This was the forced substitute that passed on it.
Narrow.
But it is one that, again, passed. One of the things it does is it does still allow the Senate to reject a confirmation by the governor, but when we have a Republican governor, Republican Senate, I don't see that really happening. But it is, again, it's just a funny thing to say, oh, the governor will be limited to 5 appointees that they can choose from, but I get to choose who chooses those people. So, concern, again, with the legal field where I'm going, let's have a little more checks and balances in place. Don't necessarily love that. This one, another one on legal services, this is one that actually attacks the sandbox.
For those online, it's Senate Bill 274 because they can't see
Senate
it.
Bill 274.
Okay.
So this one says that they have 2 things happening. So one of the things that Utah allowed, or the Supreme Court allowed, was for non-attorneys to be paid a percent of attorney's fees or to receive money for a referral. And one of the big reasons for that is because of online services. If you're creating online services, driving people to places, the marketing side can make money, different things to piece that out. And so they came and said, we can't stop the Supreme Court from doing that. We're now going to require that anyone that does that has to be licensed. And so now the
So
state...
they are requiring fees to go to licensed people only, is that what you're saying?
Yes.
Okay.
So if anyone refers somebody to an attorney and gets anything in exchange for it, they now have to be licensed. And it's a license where you have to report things consistently. You have to be background checked, fingerprinted, all kinds of things. It's a pretty onerous license. We probably require more for this license than we do for a general contracting
So what do
license.
they actually call the license?
So the license, they call them lawyer referral consultants. And it's a lawyer referral consultant license. But the reason that this is a concern is to see that the Supreme Court takes a step forward to say, we regulate law here, we're going to open it up to these things. And then the Utah Legislature says, we don't like that, we're going to put an onerous license in place if they're going to do that. We're fighting back. And again, it's important to have checks and balances. But this is one where, to me, they're working to keep things entrenched. And then the other direct attack they made in this is they said that any non-attorney that has ownership in a law firm is now subject individually to a fiduciary duty to make sure that no one is ever harmed with services, and they can be sued individually now, personal liability to them. It goes past the normal corporate veil of the shield of liability that's there, and says personal liability if you own this, which is going to push potentially most people out of the sandbox. They're not going to want to be a part of that with the threat of personal liability hanging over their head. Because these non-attorneys aren't supposed to be managers in the law firms. But they now have a fiduciary duty if someone has something bad happen. And again, to me, it's just a direct shot, right, at trying to take the sandbox down. So, interesting battle playing out. I think we'll still see these things play out. It'll be interesting to see what the Supreme Court does. This is probably one where I will probably try and run some changes to this if I can get someone to sponsor it, because it's really pulling back from where we were headed. And then I guess by way of disclosure, actually my law firm is part of the sandbox as well, so it directly affects me, people in it. And
So you like the sandbox?
I do, from the perspective of trying to increase access to legal services.
Right, so that it,
That's one of my big
Yeah.
passions, is to say
Yeah.
freedom can only exist if people can access legal services.
exactly.
And it's way too cost prohibitive right now, so economically it doesn't exist. The licenses in place, all the licenses for attorneys, have only served to squeeze the supply of attorneys, which skyrockets the fees. And it's not necessary for so many things. So for example, wills and trusts, someone could be trained to do a will and trust really well for you without law school. There's just not a crazy amount of laws in place. They could do that. Software can do most of it. You don't need the license. And we could make that accessible to so many more people if we'd open it up. And the Supreme Court knows that. And they want to do that. But again, there's this pushback.
Right now, somebody who's say working with your law firm as a referral who does wills and trusts, and you guys are paying on this side, they'd have to be licensed to do that.
Yep. Yeah, and so for example, one of the things we were setting up, it was interesting. I just finalized everything with it the day before this bill appeared publicly.
Yeah.
But we had set up where one of the things we want to do is help not only with law, access to law, but access to professional services. And we were setting up a network where it's kind of like a general contractor service network, where you could have one point of contact and say, hey, I want to start a business. I need an accountant, I need an attorney, I need a web design,
List or
something. But you just have one person you talk to, kind of like you hire a general contractor for a home, and then they go and get the services done. And to make that system work, though, you have to be able to share fees among each other and things. But the thing about it, too, is you can actually have better access. So if you have an attorney, an accountant, and a marketer that work together often, then you can get a compliant website for far cheaper because they work together. They know what their forms are, they know what their systems are. And it actually reduces the cost of the service, as opposed to you trying to get your marketer and then taking it to your attorney to review it and then going back to the marketer and doing all these back and forths. It makes it far cheaper. But that model would require a sharing of fees to make it so everyone can have that work. And they just said, everyone in that would have to be licensed if you're going to do that. If it includes attorneys, anyways. It could still include other services, but not attorneys.
And what kind of license, they have to get a business license or a law?
So it's called a lawyer referral consultant license.
That's just
Oh, they made their
fill out
own
an
app.
application, and it's
Now their own application.
They fill out an application and then give you the state a fee.
You pay the fee, you get a background check, fingerprinted, and you have to file reports. So it's not just a license you pay for. If it was just a pay-to-play type thing, that's not as bad. But this actually requires reports. It requires there's a bunch of liability on you with it. It's a pretty onerous license. It's not one of the simple ones where you just pay and then move forward.
Yeah.
So who made up the license?
The bill sponsor was McKell, Senator McKell. I highly doubt he made it up. I'm sure someone came and talked to him. I have no idea. Never seen anything like this before. Just came out of the blue.
That person who made it up, they weren't sharing fees, you know?
Probably not.
Paying him the
Under the
license.
table.
Good chance it was a big law firm who's threatened by this type of model that
Yeah,
can,
that's exactly what it is.
cut into their profits.
Did the
But
legislature see the license when you voted on it? Were they able to look at this is what's required?
I don't know. This came up. So the
Well,
session ended on a Friday. This came up the Wednesday.
Always.
So it came up 9 days before.
Yeah.
9 days before. It went through one committee. Went through the Senate committee. I think it passed unanimously. I think it passed in the Senate unanimously. By the time it made it to the House committee, they'd suspended the rules, so there were no more committees. It just skipped the House committee, went straight to
Oh my goodness.
the House floor and was just voted on.
done deliberately.
Yeah.
And so it just kind of appeared and just went bloop, right on through, and
Wow.
that was that. One of the checks and balances I want to put in place, we may have to do a citizen petition on this, But I feel strongly that they should not be able to pass a bill that hasn't been public for at least 3 months.
Yeah, yeah.
Thank you.
Yes.
Amen.
Yeah.
Sounds
To
good.
me, that's just a common sense check and balance to say,
Yeah.
if you want to pass a bill, put it up 3 months before the session so the public can see it. We have time. It's not like
Yeah.
we're scrambling and then the last week when we're all burned out of the session, you throw something up there.
Yeah.
So
I
that's,
believe that.
that actually I think would be an incredible check and balance. Maybe one we
Incredible.
should consider working on with a citizen petition. I doubt the legislature would pass it.
I think.
They start so early on their bills, so why wouldn't they?
But they can. They can put
Yeah.
bills out publicly 3
Yeah.
months before the session.
Yeah,
Yeah.
they should.
And if
That
we
should
just
be
say,
declared.
if you want to run a bill through, it has to be public for at least 3 months.
Yeah.
Amen to that.
And that gives us all a chance to be part of the process.
Why do you think they wouldn't pass the bill when it got to the legislature?
Because most of the way they get these types of bills through is to put it up
Is
the last
to-
week when rules are suspended and things
Yeah.
like that.
It's their sneak ways. that-
So why do they suspend the rules?
They do it almost every session. They're allowed to just say, oh, the rules don't matter anymore, we'll just do whatever we want.
That's nuts.
And so the last 3 days of the session, the rules were suspended and they didn't have to go to committee, bills could just pop up, run on through.
I'm so frustrated with the whole situation.
And so
Wow.
that is, again, but it was part of they needed the time, they needed to be able to do that to get the record number of bills through.
Yeah.
Yeah,
Wow.
it is what it is, I guess, I don't know.
Well, we
They
need to vote out
purposefully
the
wait for
senators.
the last minute.
Yeah. So this one, just to give you a little, this is just kind of a funny little blurb, maybe a little
Bill
comic
18.
relief.
Online
This is
dating.
HB 18. So online dating safety amendments. And again, this is talking about kind of a bigger picture thing that's happening commonly in America. This bill, if you look at it, it goes through and so it talks about these notifications and disclosures. So if you're an online dating service, you now have, if you look at the bill, it's this long list of disclosures you have to give people about safety online and the fact that you may not always be safe and about consent and all types of different things. But if you try reading it, if you pull it up and try reading it, you'll probably fall asleep. It's a long list of information. And so I look at this and say, we believe, and it's one that legislatures believe this extensively, but even as people in America, we believe the law can solve every problem. We go petition our government to solve issues and problems. And so what happens is if you go, for example, if you're a private investor in a private business, you'll be handed this document that's 100 pages long, all the legally required disclosures. And you look down at it and you go, am I okay to invest? And they say, well, read the package. And you go, but this will make some money, right? We're good to go? Yeah. All right. And then you sign. And so we're, in our effort to stop all harm, we're now throwing out just so much information, there's no way to process it, right? So now if you sign up for an online dating site, you have this big long terms and conditions, disclosures, things to click through, whatever. And the question is, now all that we've done, in my opinion, is instead of saving people,
You put the responsibility on the victim.
well, there's that, but also there's that now the business has more compliance. It's harder for an individual to start a business because now they have to have more attorneys that advise them. Is your thing legally correct? Is it not? And every time we have a consumer protection type mechanism come in place, it usually makes it harder for a smaller business to start.
Oh, I see.
But is it really saving anyone? Do we really believe these disclosures you're going to click on is going to save someone on an online dating site? Maybe there'll be someone that just is so paranoid they actually read the disclosures and go, oh, I shouldn't do this. Maybe it helps somebody. Maybe. But what it does is it again says, oh, we're here protecting you, we did something good. And now it's more difficult to start up something. And so, for example, Monsanto with seeds, they got a bunch of bills passed that made it so the seeds had to be cleaned before they could be sold to help us be safe. But what it did is it made it so that most small seed companies couldn't pay for the cleaning processes required, and most of them went out of business.
Yeah.
And so consumer protection, I just say always have a red flag in your mind when the government talks about helping you. it's probably making it more difficult for a small business to provide a service or a product.
Yeah.
And it's further entrenching the powers of, the ones with money that can pay attorneys to do all the different things.
That wanna run out of business this year.
And so this is something I saw with that, is I just went, this is so long, such a long list of what these disclosures have to say. No one's gonna read it. And what are we doing at that point? What have we accomplished? And so, again, a trend in society right now.
All the disclosure needs to say is sign at your own risk, to check the box.
Say, there are creeps on here.
Yeah,
Right? And we can't vouch for the people on this site.
Yeah. Yeah, and then sometimes less is more, right? Just to say, hey, be aware there are creeps on this site.
But you already know that.
Don't
So
trust
the fact that
everyone.
You have to sign anything or read
But
it.
again,
13-year-olds don't know
maybe there's someone that still believes everyone's good in the world. You kind of hope so. You kind of hope there's some people that still believe everyone's good. But
No, I
again,
don't hope that.
if you say something like that, less is more. That may do something.
Need to wake up.
But that's not what it said. It was all the explanations about how to keep yourself safe, how to do all these things, yada yada yada. So
Is that because if they don't put it in there, then they're liable for what they didn't put in there?
yeah, so there's penalties, there's issues, there's stuff. So now they have to put it in to disclose it, which again is just making it difficult for businesses without attorneys to start. And if you have to have an attorney to advise you on everything to start your business, you don't have any money to start a business. That's just how it goes, unless you got the big, name investors and stuff. And so, and this circles back. The same issues circle back to accessing and the sandbox and all those different things, and having those in place.